The following podcast is taken from a live broadcast on Inspire FM.
Of Ask Your Lawyer Show. I'm your host, like usual, on the last Monday of every month, Mujeeb Rahman of DotCom Solicitors. And today I'm joined by my honourable colleague, Mr. Anwar Qazi. And our last show, we spoke about homelessness and we underlined and went through some aspects of homelessness. We said, what is the legal definition of homelessness? Who owes who a duty? How is homelessness how does it happen? When are you intentionally homeless? When are you deemed unintentionally homeless? Who owes who a duty of care, etc., etc. So we did go through all that. So we're just going to do a quick reminder before we move into the actual parts that we missed out from last time. So those of you that didn't listen last time, listen in this time. I'm sure the podcasts are available on the Inspire FM webpage. And anybody that has any questions to do with homelessness, ring into the studio. We're accepting live calls. You could also WhatsApp your messages. So if you want to call in and ask a live question, the telephone number for you to call is 01582 481 822. And if you want to WhatsApp any messages, WhatsApp them to 07779 481 822. So assalamu alaikum, brother Anwar Qazi. How are you?
In our previous show, we provided some general overview advice on homelessness, and we said that we will have further discussions on this topic. It's an extensive and complex area of law, and today we will continue with homelessness, but discuss more specific about some elements of housing.
No problem. As I've stated in the introduction, that we're gonna go through some of the things that some of the aspects, shall I say, that we went through in the last segment. Now, Mr. Qazi, do housing authorities have a duty to provide or secure anything for anybody, or could you just go through the duties and who owes who a duty briefly, just for, I guess?
That's right. Business. Yeah, housing authorities have a duty to provide or secure the provision of advice and information about homelessness and the prevention of homelessness free of charge. This is only we're talking about advice. Okay. And these services will form part of the offer to applicants who are owed other duties under Part 7. Part 7 is Part 7 of the Housing Act 1996, which mainly deals with homelessness.
The prevention of homelessness.
Exactly.
Okay. And should this be available to any person living within that district or in that borough? Is it specifically generic for everyone?
Information and advice, duty to provide information and advice apply to even those who are not entitled to assistance, including those, for example, have some kind of restrictions on their migration status, or those who are found intentionally homeless. The council, the local authorities are under duty to at least provide advice or provide some kind of guidance to them. Yeah, exactly.
So basically, just in a nutshell, to answer that question, Mr. Qazi, you're saying that the person seeking advice could go to any borough, any district. You don't have to be owed a duty by that district. You don't have to be a registered resident within that district, and they will help you and assist you further.
Well, yeah, that's right. But my advice would be that you approach your nearest council or the council that you have local connections or you have lived there for some time, or even you're working in that borough. So yes, generally you can approach any councils, and as I've said before, that any issues concerning homelessness, and if you realize your rights are not obeyed, or you did not receive the facilities or advice that you the services that you needed, you can approach solicitors for these type of advice. And when I talk about advice and information, I'm actually talking from section 179 of the Housing Act 1996, and section 179 specifically provides that authorities must provide information and advice on preventing homelessness,
right,
securing accommodation when homeless, the rights of people who are homeless or threatened with homelessness, and the duties of the authorities, and any help that's available from authority or anyone else for people in the authorities district who are homeless or may become homeless within 56 days.
Okay. Now, I remember in the last segment, I'm just trying to juggle my memory a bit as well. We spoke about applications. We suggested that when you're about to become homeless, approach your council, make your applications, etc. What's the procedure for early applications, etc.?
You see, that general advice is, or my advice would be, that if you feel you're threatened with homelessness or you're about to become homeless, then it's advisable that you approach the council at earliest possible stage. That will at least give time the local authorities to consider your application. But within Housing Act is 56 days.
Okay, so if you're going to become homeless within 56 days, make your applications for homelessness to seek assistance, and maximize the time and opportunities available to you in order to prevent you from being homeless.
Exactly.
And you could seek these informations, as we previously mentioned, through your local authority websites. And they might have other channels available for you, as in subsections or sub-offices where they provide certain specific advice to do with homelessness.
That's right. Early applications for homelessness assistance maximize the time and opportunities that available to prevent homelessness. Information provided through authorities' websites and other channels, actually. So it's quite advisable that people faced with homelessness to approach the local authorities as soon as possible.
And what does this enable people to do?
Enable people. Well, it will enable people to take action themselves where possible. Actively encourage them to seek assistance from the local authority in good time if they need it.
Interesting. I know we spoke about section 179 subsection 1, where you were talking about the prevention of homelessness and have you. Again, listeners, please don't get a bit worried if we're mentioning sections. It's just, I know we need to forget the fact that we're lawyers, but unfortunately that's how we remember things through the sections and the subsections. But subsection 2 of section 179 states that housing authorities, and we mentioned this in the last segment as well, that the housing authorities are under obligation and they must design advice and information to meet the needs of people within their local district or catchment or borough or whatever you want to say. And there's specific groups that take more importance or precedence over others. Now, what are these groups, Anwar?
Yeah, first of all, you talked about provision. We have a statutory laws, which are acts of parliament, and then we have common law cases, precedent cases, made by judges. So let's not forget that. And section 179 states that housing authorities must design, advise, and information services to meet the needs of people within the district, including in particular the needs of different groups: care leavers, former members of armed forces, victims of domestic abuse, people leaving hospital, people suffering from mental illness and impairment, and some other groups that requires urgent assistance.
And what type of people or what type of authorities or service providers will housing authorities need to work with?
Housing authorities will need to work with other relevant statutory and non-statutory service providers to identify groups who are at particular risk and to develop appropriate provisions that is accessible to those who are likely to need it. And here we're talking about charities, about housing associations. So in general terms, the local authorities can delegate their functions. But overall, they do need to meet their duties and obligations under Section 179 of the Housing Act 1996.
Okay. So they just need to prepare for these kind of people, have tailored advice for them.
The aim is to make sure that those who are in priority need of housing assistance to be identified and make sure that they do not face any hardship or homelessness in their lives, and to prevent them from affecting their health and their welfare and so on.
Okay, but many people that risk or are concerned about the risk of homelessness, what will they be practically seeking?
Most people concerned about risk of homelessness will be seeking practical advice and assistance to help them remain in their accommodation and secure alternative accommodation. Let's not forget, actually, this type of general advice provided by the councils, by the local authorities. Obviously, they will not provide some kind of detailed advice about their housing situation or if they're homeless or threatened with homelessness. It's quite advisable that if they are faced with any issues concerning homelessness, to approach solicitors. They can advise them in a proper, detailed manner.
Appropriate fashion. What advice on the following issues or on the following issues may help prevent people from becoming threatened with homelessness?
Tenants' rights and rights of occupation, what to do about harassment, threats of illegal eviction, rights to benefit. And we're talking about welfare benefit, housing benefit, council tax support, and how to protect and retrieve rent deposits, rent and mortgage arrears, how to manage debts. All these information come under Section 179, and we have discussed this topic before. You see, about illegal eviction, about harassment, about the rent deposit scheme, and we've repeatedly said that if those landlords who are not following these requirements will have
severe
difficulties, consequences in evicting their tenants from their properties.
Indeed, and obviously people getting risk from violence and abuse, grants available for housing repair and adaptation, obtaining property in the private sector. And a lot of councils encourage that and actually help towards that as well, don't they?
That's right.
Apply for social housing and how to access a shared ownership or other low-cost home ownership schemes.
Section 179 of the Housing Act 1996 places obligations on the local authorities to make sure that you follow these duties, comply with certain conditions, to make sure that people who are homeless or threatened with homelessness are protected or are assisted.
Not on the streets,
exactly. That's the purpose of Section 79.
Now that we're talking about Section 179, we spoke about this in the last segment as well. Section 179, subsection 4. What other type of people? What other type of persons or people will housing authorities also assist with?
Section 179(4), housing authorities may also assist such people like voluntary organization by allowing them to use their premises belonging to the housing authority, making available furniture or other goods by way of gift, loan, and some other arrangement, make available the services of staff employed by the housing authorities. In general term, housing authorities should monitor the provision of advisory services to ensure that they continue to meet the needs of the sections. And the sections of 1794.
Okay, now, I mean, we spoke and we obviously keep saying homeless, or if you're threatened with becoming homeless or anything like that. So shall we discuss how to determine if a person is homeless or threatened with homelessness?
Absolutely. A topic, a complex, wide, quite useful
information.
And I'll discuss about how to determine whether a person is homeless or threatened with homelessness for the purposes of Part 7 of the Housing Act 1996.
Right.
And one of the sections I intend to mention is 184. If a housing authority has a reason or reasons, or has a reason to believe that a person applying to the housing authority for accommodation or assistance in obtaining accommodation may be homeless or threatened with homelessness, it must make inquiries to specify itself whether the applicant is eligible for housing or for advice, and if any or all to that person. And we discussed this before. You see, when people or applicants approach the local authorities for housing assistance, then the local authorities are under a duty to make a decision, a written decision.
Okay, what about those that are threatened with homelessness?
I'll go further. Is section 175 for a person is threatened with homelessness if they're likely to become homeless within 56 days. Previously it was 21 days, and I think came to light that 21 days are quite short, and the councils or the local authorities may not have enough time to make decisions. That's why they've come up with a kind of early taking action quite at earlier stages, that is 56 days.
All right. Okay. What are the number of different factors? Because I know there's a few factors that
section 175.5, a person is also threatened with homelessness if a valid notice under Section 21 of the Housing Act 1998 has been issued in respect of the only accommodation available for their occupation, and the notice will expire within 56 days. We have discussed about Section 21 before. In Section 21 of the Housing Act 1998, landlords do not need to give any reasons, but at the same time must give a reasonable time to the tenants to find an alternative accommodation. So what section 1755 is doing, that if your section if the Section 21 notice is going to expire within 56 days, it's advisable that you approach your local authorities for housing assistance and advice.
Okay, just to clarify, Anwar, is everybody threatened with homelessness eligible for assistance, for argument's sake?
Well, it's quite difficult to answer this question. Section 195 provides that where applicants are threatened with homelessness and eligible for housing assistance, housing authorities must take reasonable steps to prevent their homelessness.
Okay, so no matter who you are, what you are, the housing authorities in your
But
catchment should.
There are exceptions, you see, Mujeeb. Yeah, exactly. I really want to say, imagine you own properties elsewhere. You see, there are other factors that may make you ineligible. But when it comes to advisory services, it's not limited.
Okay, no problem. We're going to be going off on a short break soon. But do stay tuned in. So, as you've just heard, Mr. Anwar, he was just explaining the different factors that are there to be assessed if you are threatened with homelessness. When we're back from the break, he's going to discuss and inform us of the different factors that are there that will determine whether a person is homeless or not homeless. So on that note, inshallah ta'ala, we're going to go off for a short break now, and inshallah we'll be back shortly. So stay tuned with us, and I'm your host from the Ask Your Lawyer Show, Mr. Mujeeb Rahman, and I'm joined with my guest, Anwar Qazi. Assalamu alaikum.
You're listening to an Inspire FM podcast, making available our popular programs from our daily broadcast on Inspire FM.
Assalamu alaikum wa rahmatullah, everybody. Welcome back to the Ask Your Lawyer Show. I'm your host, Mujeeb, and I'm joined with my colleague Anwar Qazi, also of DotCom Solicitors. Assalamu alaikum wa rahmatullah.
Wa alaikum assalam, Mujeeb. Yeah, we previously provided an overview about homelessness, and it's quite advisable to our listeners that if you're faced with homelessness or threatened with homelessness, that you approach the local or your local authorities as soon as possible. Earliest is better than being late. And although there are legal duties on local authorities to provide advice and information, and also give access to all this information that you need for your housing issues, it's quite advisable that if your application is refused or rejected by the local authorities, that you approach solicitors to assist you. It's quite really important. Having housing problem will have severe effects on your life and on life of your family
and your health,
and therefore it's very necessary and important that you either seek assistance or advice from the local authorities, or alternatively you can approach solicitors or for more specific advice. And I say that if our listeners have any questions tonight, they can call us through Inspire FM or leave their numbers with Inspire FM, and we will definitely contact them back.
Okay, so you just said it affects your families, affects your health related to issues, it affects your whole household becoming homeless. Right, so now, Mr. Qazi, what will constitute to a person or applicant's family or household, just for the purpose of the application?
Yes, Section 176 provides that accommodation shall be treated as available for a person's occupation only if it's available for occupation by them together with any other person who normally resides with them, such as family members or any other person who might reasonably be expected to reside with them.
Okay, so it's subject to reasonableness. It covers your family and anybody that's reasonably believed or perceived to be living with you.
That's absolutely right, yeah.
Okay.
Yeah. And both these groups of people constitute member of applicant's household or accommodation will only be considered to be available if it's available for occupation by both the applicant and all members of their household.
Okay, so it's not even though you're applying as a single person, includes everybody within that household that you're
exactly
applying.
that. And then suitability of property comes. We will discuss at later stages that property needs to be, even if you're a single applicant, and that property needs to be suitable, not just for yourself, but also for your family members.
Okay, no problem. Thank you, Mr. Qazi. But this brings out another question now. Who has the legal right to occupy the accommodation?
Section 175 still goes on. 175.1, a person is homeless if they have no accommodation available for occupation in the UK or somewhere else, which they have a legal right to occupy by having interest in it, such as the owner, the leaseholder, or the tenant, or any kind of court order. And then it goes further. Legal right to occupy can be from an express or implied license to occupy, such as a lodger, as an employee with a service of occupancy, or when living with a relative.
Okay.
And it goes on further. Any enactment or rule of law, or any, let's say, provisions or common law giving them the right to remain in occupation or restricting the right of another person to recover possession. For example, a person with the right to retain occupation under a statutory tenant under Rent Act 1977, where that person's contractual rights to occupy have expired or been terminated.
Okay. What happens if a person's been occupying accommodation as a licensee, but the license has now been terminated?
Yeah, a person who has been occupying accommodation as a licensee, or whose license has been terminated, or who does not have any other alternative accommodation available for their occupation, is homeless.
Okay.
Why? Because they no longer have a legal right to continue to occupy that property or dwelling, despite the fact that that person may continue to occupy. He might physically be occupying that property, but he doesn't have any
legal right
any
to remain
legal rights,
Yeah.
but as an unauthorized occupier. This may include, for example, those required to leave hostels, hospitals, former employees occupying premises under service occupancy, which is dependent upon contracts of employment. Those who lose their employment, and at the same time they lose the facilities or the accommodation that they were provided.
Okay. Thank you, Mr. Qazi. Just a bit before this question, you were talking, and it just brought something to my mind. You're talking that, and you're stating that if a person has a family home or interest in a property or or family home, for example, most people from the Asian background, they live with their parents.
That's right.
The house might not particularly be theirs; it might be on the dad's name, but they're just living with their dad, so they have a kind of equitable interest within the property, so to speak. So, what happens if their dad or the family tells them to leave the accommodation?
First of all, understand most people do live with their family members, but life circumstances or suitability of accommodation and things like that. Some applicants may have been asked to leave their current accommodation by family or friends with whom they have been living. In these cases, the housing authority will need to consider carefully whether the applicant's license to occupy the accommodation has in fact been revoked. And we had so many of these cases where we were approached by clients and have said that, look, I've been living for a number of years with my family, and now I've got children and other needs. And well, they can indeed approach the local authorities for assistance, but just they're insisting that this type of applicants or their applications need to be considered quite carefully to make sure that the licenses or whatever legal rights they had in that property are revoked.
Mm-hmm. In some circumstances, what if the applicant is unable to stay in the accommodation?
In some cases, the applicant may be unable to stay in their accommodation, and in others, there might be scope for preventing or postponing homelessness and providing them with an opportunity to plan their future accommodation with assistance from the housing authorities. When you approach the local authorities for assistance, first they try to negotiate with your landlords to find out or to establish if there are any rooms where you can remain in your current accommodation, and same applies to those living with family members. Local authorities may discuss with their family members to see if there are any kind of solution where or compromise where the applicants can remain in that property, or request for some more time to let them stay in their current accommodation until the local authorities find or come up with some kind of plan.
Okay. What about people that actually have nowhere to go and they've got genuine difficulties in finding alternative accommodation?
People living with family and friends may have genuine difficulties in finding alternative accommodation that can lead to friction and disputes within their current home. In some cases, external support or the offer of assistance with securing alternative housing may help to reduce tension and prevent homelessness. The use of mediation service may assist here.
As you mentioned.
Yeah, exactly. So there are some circumstances where people do have some issues. But having said that, you see, when we talk about issues, the housing, Part 7 of the Housing Act, give priority to those who are the victims of domestic violence. It's quite visible that if you're suffering from any type of violence, domestic abuse in your family home, then it's very advisable that you approach the local authorities as soon as possible. They will take your cases or your application seriously, and they will make sure that you are assisted in every way possible.
Okay. What about in cases where people are like 16, 17 years old, they're threatened to be kicked out of their family homes?
In cases,
what happens for these young adults or young teenagers?
In cases of 16, 17, quite young age, all threatened with exclusion from family home, children services, or normally, I think normal word we use, social services, will be the lead agency, but should work closely with housing authorities to prevent homelessness and support young people to remain within the family network wherever it is safe and appropriate for them to do so. So they're more into pointing out to our social services that they need to make sure that these youngsters 16 and 17 are assisted, and social services can approach the council on their behalf to make sure that they have suitable accommodation or place to stay.
That's fine. Is there anything else or any other aspects that the housing authorities will need to do?
Housing authorities will also need to be alert to the possibility of collusion where family or friends agree to revoke a license to occupy accommodation that would have been reasonable for that person to remain in that property, to continue to occupy the property as part of the arrangement whose purpose is to enable the applicant to be entitled to assistance under Part 7.
Okay. Thank you, Mr. Anwar. What if the individual has not got any ability or is unable to secure entry to accommodation or anything like that?
That's right, inability to secure entry to accommodation. some circumstances you may have an arrangement with family members or friends that you can live in that property, and suddenly you find yourself in a situation where you cannot gain access to that pre-arranged accommodation or place. Under section 175(2)(a), a person is also homeless if they have a legal entitlement to accommodation but is unable to secure entry to it. It's quite clear. For example, those who have been evicted illegally or unlawful eviction, we do find some clients where they approach us that their landlords have just changed the locks of the property, and or those whose accommodation is being occupied illegally by squatters. We have something squatters' rights. We really don't want to talk about squatters' rights. And then we have situation where people are occupying an accommodation with their family members, and suddenly they're, due to some issues, they cannot gain access to that property. So these type of people do need to be treated as homeless.
What would be reasonably, or what is considered reasonable to continue to occupy?
Reasonable to continue to occupy an accommodation is section 175(3) provides that a person shall not be treated as having an accommodation unless it is accommodation which it would be reasonable for them to continue to occupy. There are a number of provisions relating to whether or not it's reasonable for somebody to continue to occupy accommodation, and these there's not a simple test of reasonableness. It is for the housing authority to make a judgment on the facts of each case, taking into account the circumstances of the applicant. It's basically case by case basis, more into factual, and so it's placing a duty on local authorities to take into account all the facts of the applicants. Yeah.
Okay. Now, Anwar, we mentioned domestic violence, and domestic abuse and domestic violence quite a bit. Now, when is it not reasonable for a person to occupy a property if they're subject to domestic violence?
That's right. When it comes to domestic violence, the law is quite extensive and tend to protect those who are going through domestic violence and abuse. But when it comes to housing, first you will be given priority if you are a victim of domestic violence, and further more is section 177(1) provides that it is not reasonable for a person to continue to occupy accommodation if it's probable. Even when it comes to the word probable, even those who are not victims of domestic violence but maybe
are subject to
that this will lead to domestic abuse or other violence against the applicant, or a person who normally resides with the applicant as a member of the applicant's family, or any other person who might reasonably be expected to reside with the applicant. If it's very advisable for our listeners, those who are listening to our show, that if you are going through domestic violence and you're concerned that you may not have a place to live, that's wrong. Basically, if you're a victim of domestic violence, you do need to approach the local authorities as soon as possible, and they will make sure that you do not face any homelessness, or you do have a reasonable place to occupy.
Okay. Yeah. Okay, now, Anwar, I know when it comes to homelessness, affordability is a big aspect that the council will look at.
Councils generally housing circumstances in the district is section 177(2) provides that in determining whether it's reasonable for a person to continue to occupy accommodation, housing authorities must have regard to the general housing circumstances prevailing there in the housing authorities district. Affordability must be considered in all cases. This just to make sure that these those who are offered suitable accommodation do not lose their properties for rent arrears and things like that. So affordability must be considered in all cases. The Homelessness and Suitability of Accommodation Order 1996 requires housing authority to consider the affordability of accommodation for the applicant.
Right.
The order specifies, among other things, that in determining both whether it would be or would have been reasonable for a person to continue to occupy accommodation and whether the accommodation is suitable, housing authority must take into account whether the accommodation is affordable for them, and must in particular take into account financial sources available to them, the costs of the accommodation, maintenance payments to spouse, former spouse, or in respect of, let's say, children, child maintenance, and the reasonable living expenses.
That covers the shopping utility business.
Absolutely, yeah. The councils do have a duty to do an affordability check to make sure that these applicants...
It's not out of their remit, yeah.
Exactly, do not face some kind of financial problems in future. That's the purpose.
And those that are really interested and are affected by this, you could see further guidelines on affordability from Chapter 17 of the... right.
That's right. We did have some clients where they've come up says, look, the rent not so high, or affordability check was not done properly when they were offered the property. So if you have any concerns when it comes to affordability, you can either approach your local authorities for further advice and information, or approach solicitors to assist you with those kind of events.
Those of you who just tuned in, welcome to the Ask Your Lawyer show. I'm your host, Mujeeb of DotCom Solicitors, and I'm joined by my colleague, Mr. Anwar Qazi, also of DotCom Solicitors. And those of you not knowing the topic we're talking about homelessness today. So if you've got any questions and you want to call in and ask us a question, feel free to call in on 01582 481 822, or those of you that just want to WhatsApp your questions or anything, you could WhatsApp your questions to 07779 481 822. And we've literally got 6 minutes left till the show's ending, so I'll move swiftly forward back to my guest. Now, Anwar, what happens if a tenant is given notice of intention to recover possession? If you could just be a bit patient.
I'll be trying to be fast, but having said that, Mr. Mujeeb, what as solicitors, especially being a housing solicitor, talk about housing matter here, what is our job? What is our aim? Our aim has always been to assist people and help people with housing problems and difficulties. Yes. And although the legal aid is there for those who cannot afford their legal fee, and our sole job, our purpose is to assist them, to make sure that we make some kind of changes or differences
to ensure that they've got reasonable living standards.
Exactly, that's our duties, and these duties, there are further duties placed on us by our regulatory body, the Solicitors Regulation Authority. And coincidentally, today is the 25th November, a new code of conduct came into force. Is standard regulations by the Solicitors Regulation Authority for solicitors, or for those who are regulated. Anyway, tenants given notice of intention to recover possession in cases where the applicant has been occupying accommodation as a tenant, or has received a valid notice to quit, or a notice that the landlord intends to recover possession. We're talking about Section 8 notice, Section 21, or even notices under their tenancy agreements. Housing authority should make contact with the landlord at an early stage. This will be necessary both to understand the circumstances in which the applicant has become threatened with homelessness, and to establish what reasonable steps may be taken by the housing authority and by the applicant to prevent their homelessness. And that's generally these local authorities do follow this. As soon as you make an application they do approach your landlord to see if they can find some kind of solution.
Okay. Can the housing authority give a notice to end?
Housing authority can give notice to end the section 1952 prevention duty, where 56 days has passed since the prevention duty was accepted, whether or not the applicant is still threatened with homelessness. It's section 1958B. However, section 1956 of the Housing Act 1996 prevents an authority from doing this if the applicant has been given a valid section 21 notice which will expire within 56 days or has already expired in respect of the only accommodation available for the applicant's occupation.
Okay. Now, what would be reasonable in determining whether the applicant is reasonably allowed to continue to occupy a property or accommodation?
In determining whether it would be reasonable for an applicant to continue to occupy accommodation following expiry of a valid section 21 notice, the authority will need to consider all the factors relevant to the case and decide the weight that each should attract. So basically what the local authorities need to consider each applicant's application carefully and take wider, exactly, it's case by case basis, and make sure that they provide the advice and assistance that the applicant requires.
Okay, so just to sum up today, we spoke about homelessness. Just to give you a paragraph before we finish. Housing authorities should ensure that homeless families and vulnerable individuals are owed duty and are not evicted throughout the enforcement of an order or possession as a result of failure by the authority to make available to them a suitable accommodation. So the local authority, in simple terms, does have a duty towards you to house you. On that note, Jazakallah khair for tuning in, and inshallah we shall see you when we're here next with a new topic, inshallah. And on that note, Assalamu alaikum.
Thank you for listening to our podcast. We stream our daily broadcast on inspirefm.org. You'll find all our daily updates on our social media at InspireFM Luton.